Super. Well, welcome everyone to the session on non-signatories and arbitration agreements with a comparative view. I'm delighted that I'm joined by Noah Rubins from Freshfields in Paris and by Timur Aitkulov, who is at Clifford in Moscow. And we're looking forward to having an interactive session. And we're going to have all the participants be upgraded to panelists because we really welcome your interventions, comments, and questions. Now, if you would, in the beginning, we will have you all on mute as we just get started, and then we will unmute you as we get into the discussions. But if at any time you would like to make a comment, please just indicate by raising your hand, waving your hand function, which we should be able to see, hopefully. Or you can also in the chat function indicate that you would like to make a comment or pose a question. So this session is for all of us to share with each other. And so let's make it a really active session. Quick important notice, we're recording. So I hope everyone, by staying on and participating, is giving their assent to being recorded. We also will be having 4 polls that we will show, present during the session, and we would really appreciate if everyone would respond to the poll so we can share the results and will help to generate our discussions. So with that, let me just indicate briefly that there's so many topics which we could discuss within our session, and we're hoping to cover a range of them. One of the main things that we're going to be looking at, of course, are what are the ways in which non-signatories are brought into an arbitration. And we know that there are a number of legal theories which are used in bringing non-signatories either into the role as a claimant or into the role as a respondent. And we might explore a bit what is the difference there. To launch, though, I think it's important, our starting point is that we all agree that consent is the foundation to arbitration. So we have to have consent. And so these theories lead us to finding that there is consent to be a party to the arbitration agreement through one of these theories, which could be implied consent through activities or through estoppel. It can be through agency. It can be through guarantors or sureties. It can be through unified contracting relationships, group of companies. So there are a number of theories which are used, and they may not be used, in fact, indeed, are not used in different jurisdictions in the same way. And they're all based in civil law, which also means that the theories themselves may have some different contours and whether or not they're actually accepted. And we will be exploring a bit what is the situation from the point of view of the arbitrators determining who's a party, a court at the seat who's asked to review the award, or a court at enforcement asked to recognize and enforce, and what deference, if any, is given to the fact-finding of the arbitrators or to a decision by a seat court. So with that, we're going to explore these exciting issues, and we look forward to all of you contributing to the discussion. And I'm going to start by with the first poll. Oksana, can you show the first poll? And to those of you just entered, you're all going to become panelists soon. So the first poll, have you ever encountered non-signatory issues in your own cases, either as counsel or arbitrator or both? So is this an issue which you're finding is actually occurring, or is it one that's more interesting for discussions at webinars and in classrooms? We see the results coming in, and it appears that there is quite a number of those of you replying who have dealt with non-signatory issues. So we'll give you about 10 more seconds.
Does everybody know how to vote? Because we've got a lot more people than we have voters here. No abstentions.
Important to have an opinion. We're all lawyers. We should be opinionated. Not asking you whether it's good or bad, just if you've encountered it. Okay. Couple more opportunities to vote.
Yeah,
Okay, with that,
Patricia, on my screen, it's showing that hosts and panelists cannot vote. So for some reason, I guess when everyone got promoted to a panelist, that may be why the votes aren't coming through.
okay,
Can we change that, Oksana? Make sure that everyone can vote.
Let me see. Well, Daniel and I, we can quickly do the promotion to panelists, shall we?
yes, I think that the issue was that if you're a panelist, you don't get to vote.
Exactly.
Yeah, doing that.
So if you can let panelists also vote. But in any case, let's we have so many things to discuss, but let's conclude that it seems that most of you perhaps, have encountered non-signatory issues. Hopefully your colleagues in the contracting department or your clients have considered these things at the time of contracting, because it's a lot easier to make arrangements for being able to get your hand into the deep pocket at the time of contracting than asking the arbitrators to do it at the time of dispute. But we do, as lawyers, have some tricks up our sleeves and some legal mechanisms to try to solve that. And so I would invite Noah to maybe launch us into the discussion.
Sure, thank you. So it is important to think first and foremost, what's the applicable law? If every law in the world, every system of law looked at non-signatories to arbitration agreements in the same way, it wouldn't matter much, but that is definitely not the case. There's a huge amount of variety, and indeed, one of the odd things about the binding of non-signatories is that it's very rare in national laws, legislation on arbitration, to have anything said at all on the issue of non-signatories. Very often, national laws will say something about the need for a written agreement, although it doesn't say anything about the need to sign that agreement. And most modern arbitration laws don't require that either. A written agreement to arbitrate is often not required either. And what you see is a development through court experience, jurisprudence in the enforcement and blocking of enforcement, confirmation and annulment of arbitral awards, of a variety of different approaches in applying legislation which is often broadly similar on the issue. That is to say, permissive, it could be, under the explicit words of the laws on arbitration. And what you get is broadly three different approaches. You get the approach where an arbitration agreement is just a contract, like any other contract, and the question as to whether a non-signatory is a party to that contract to arbitrate is the same as the analysis that one would engage in with respect to any other contract. Another set of countries take a stricter view. It's actually more difficult to establish an agreement to arbitrate with a non-signatory than it would be with respect to some other kind of agreement. And a third category of countries, which is probably the smallest number of countries, with France in the lead perhaps, has a tendency towards a more permissive view. That is to say, it seems to be easier to bind a non-signatory to an agreement to arbitrate than to other forms of contract. And that doesn't mean necessarily that the courts are ignoring the question of consent, which Patricia brought up. To the contrary, most courts in most countries around the world start almost every analysis with the question as to whether there was consent. But the kind of evidence and the weight of evidence required in order to establish that consent in a situation where the party in question is not obviously by signature, by direct accession, a party to that agreement is very different from place to place. And so the question as to how you choose that is central to any analysis. Now, many people, when they first look at the question, say, well, it's obvious. You know, there's a governing law to the contract, and that governing law of the contract is naturally going to apply to the arbitration clause as well. Well, that's a logical approach. In many countries, if not most countries, the legislation on arbitration provides for the separability of the arbitration agreement, but that only says that it could be a different law, not that it will be a different law, or that is usually a different law, or not usually a different law. Or is it the place of arbitration? And many people say, well, that's the natural thing, because in any event, you got to make sure, if you're the arbitrators, that the award that you're rendering against or in for the benefit of a non-signatory is enforceable someplace, and that will depend in large part on whether it stands at the place of arbitration. And then some other people may say, well, no, neither of those is any good, because the non-signatory will naturally say, well, I didn't agree to the governing law, and I didn't agree to the place of arbitration. So why should I be bound to any agreement with respect to the law applicable to that agreement that I didn't consent to? Also quite logical. And those people will tend to say, well, it should be the law that is the law of the place most closely connected to the contract. Mark Blessing wrote a very good article many years ago looking at this issue, and he found 9 different approaches to the choice of law, 9 different ways to get at it, of which those 3 that I've mentioned are the most prominent. I'd like to hear everyone's views on this in just a moment, but I thought we'd first do another poll based on a very quick scenario. The scenario is this. You have company A, which is the head company of a group of companies that are engaged in industrial production. And company A has a subsidiary, company B, which is the actual manufacturing subsidiary. Company A contracts, company B contracts with company C, which is the head of another group of companies that makes one of the ingredients in company B's product. And that product is made by subsidiary D. So you've got A and B and C and D, where it's the sub of the one group of companies contracts with the parent company of the other group of companies to buy a product. Right? Now a dispute arises, the agreement calls for ICC arbitration, English law, a Paris seat, and the closest connection is with Venezuela. Right? That's the scenario. And a dispute arises between the A and B companies and the C and D companies, and the A and B companies A and B sue companies C and D in ICC arbitration. And the question is, if you are on that tribunal, would you find that there is jurisdiction with respect to the non-signatory claimant? And would you find jurisdiction with respect to the non-signatory defendant? I'll make it a little bit easier and say that you have found, as a matter of fact, that all 4 companies were involved in the negotiations of the contract in some way, and all 4 of the companies were engaged in some way in making sure that the contract was performed. All right, let's pull up poll number 2, Oksana, if you would. So the first question is with respect to the claimant. The second is with respect to the respondent.
So based on the circumstances that Noah just presented, how would you decide? Multiple choice. Please, everyone, do vote. Hopefully everyone is able to vote. We don't have very many who've voted yet.
There we go. We got 10 now.
Yeah, we got to get more. You're not allowed to abstain, as Noah said. You're getting paid as an arbitrator. And so you're forced to have to make a decision here. Okay, you got a few more seconds to make a decision. Otherwise, the ICC is going to dock your pay.
Excellent. Very good. Keep voting those who haven't voted yet, but let's just take a quick look at this. Very interesting, first of all, that there is a difference of opinion, right, on both the claimant and the respondent. Very interesting. So it's not obvious. And it's also interesting that more people thought that there should be jurisdiction over the claimant than over the respondent. Now, as you may have recognized, the case that I was describing was something like the Dow Chemical case from the early 1980s, which has become in some ways the leading group of companies doctrine case. Now, what I'd like to hear from people is why you voted the way you did. But before that, just one point about Dow Chemical that many people don't quite realize is that in Dow Chemical, French law was not applied to the question as to whether there was an agreement to arbitrate with the claimant non-signatory. There was only a claimant non-signatory in that case. And jurisdiction was upheld over the claimant non-signatory based on general principles of practice and law prominent in the ICC practice. And the sense is that that tribunal and the Paris Court of Appeal that came afterwards to affirm the award took the view that, well, if the parties agreed to the ICC rules, that should be the governing law with respect to the question of non-signatories. So anyone out there want to tell us why you voted the way you did? And it's interesting that, again, not the same people voted for someone didn't just vote yes, yes, or no, no. Anyone want to offer their views why they voted the way they did?
Hi, good evening, everyone.
Hi.
Can I butt in? Hi.
Yes, please. Who's that?
Judy. Yeah, this is Judy from the Philippines.
Hi, Judy from the Philippines.
Yeah, I voted that the claimants, both the signatory and non-signatory claimants, would be held by the jurisdiction, would be bound by the jurisdiction, and the non-signatory defendant would not be bound by the jurisdiction.
Why?
I voted that way because well, as I would assume in my jurisdiction, the claimant, of course, would necessarily have given consent by the fact that they filed the claim. So the non-signatory, by participating in the claim or in the complaint, necessarily gives the consent. With respect to the non-signatory defendant, I'm assuming that if the seat is Paris, there would also be probably a separate legal personality. They would consider Paris law, would consider the separate legal personality between C and D as parent and subsidiary companies. And that's the same law here in the Philippines, that parent and subsidiaries would have separate legal personalities. And also that would depend probably in the language of the contract. So if the contract, the arbitration contract says that it is simply the parent company that is bound, I would assume that it would be difficult to bind subsidiary D as a defendant. And also that would go into the issue of enforcement as well, I think. If they enforce it, for example, in Venezuela, the Venezuelan courts would probably also consider whether there's a separate legal personality between C and D as defendants.
Thank you.
So
thank you very much.
That was my analysis.
Thank you very much. And it's interesting to think, of course, from the respondents, the signatory respondent's perspective, he says, but I didn't agree to be sued by that guy. I didn't agree to be in an arbitral proceeding with that guy and have an award that's enforceable under the New York Convention around the world from that guy. That's not I didn't sign with him. Yeah, go ahead.
If the arbitrators find that along the line that Judy from the Philippines indicated, that the claimant has consented, would you find that the same consent would apply to a counterclaim against them on liability under the contract?
I would have thought absolutely. I have a little bit of trouble with the idea that you can show consent at the time of contracting by opportunistically suing much later on when the dispute arises. Things are a little different. I have a little trouble with that proposition, but absolutely what's good for the goose is good for the gander, and there's no way you could avoid a counterclaim, I think, if you affirmatively go in and say, I'm not a signatory, but everyone consented that I should be a party.
Are there more comments out there? Everyone agree?
What's next on our agenda, Patricia?
Well, just before we leave this, let me ask you, Noah, do you think that it is appropriate, and you find in practice that even if it's not a legal standard, that respondents being bound is treated differently than claimants taking advantage of non-signed clause?
It's an excellent question. The answer is yes. Not necessarily for the reason, not quite for the reason that Judy pointed out. In the United States, there actually are cases that go to the question of the difference between claimant and respondent. The difference is that for the respondent is denying any participation in the contract, whereas the claimant normally is, with respect to the claimant, the respondent is normally saying, I accept that there's obligations under the contract, just not the arbitration clause. So there's a bit of a difference in terms of accepting the whole kit and caboodle and accepting obligations in the contract. The respondent is a signatory, where the respondent is a signatory. The respondent is saying, yeah, I'm bound by the contract, but I didn't agree that guy should be able to sue me. Someone else may be able to sue me under the contract, but not him. Whereas where it's reversed, where the respondent is a non-signatory, the respondent is then saying, I'm not a party at all. I shouldn't be sued under this contract at all. So I think there is a difference.
Yeah, and we can say, just before we pass over to Timur, who's going to present a very interesting, very recent Russian case on this issue. Probably many of our participants are aware of the GE decision recently decided by the US Supreme Court, which was a fairly narrow issue of whether or not the New York Convention has room for the doctrine of equitable estoppel. You referred it back to the circuit court to actually determine. But in that case, GE, who simply put was a guarantor of certain obligations, was in the claimant position trying to use the arbitration agreement to obstruct the litigation. So we see this issue continuing to come up. With that, should we invite Timur to share with us the Russian case?
Thank you, Patricia. Hello, everyone. Yeah, indeed, there is a recent case by Moscow Arbitrage Court, which is quite amazing from the point of view of Russian court practice, because there haven't been a single case before that when courts actually acknowledged jurisdiction with respect to non-signatories to the arbitration agreement, other than in situations of universal succession, assignments, and things like that. So this is kind of really novel case. What is troubling actually that it's kind of difficult to see any any reasonable grounds for such conclusions by the court. Of course, I'm not impartial here because I represented the parties which were non-signatories, and with respect.
Well, you didn't tell me that before.
I did. I sent you the judgment which mentions who represented whom. Oksana, can you please start the slides? Yes, you can see here the number of the case. The ruling was entered into on the 21st of August. And that ruling was to set aside, to dismiss an application to set aside an arbitral award. So the proceedings were seated in Russia. Applicable law was German. Language of the arbitration proceedings was German. The arbitral institution which administered the proceedings was Arbitration Court at the Moscow Chamber of Commerce and Industry. And from 1st of November 2017, when the Russian arbitration reform took effect, and that institution could no longer administer proceedings, the proceedings continued allegedly as ad hoc proceedings. The tribunal consisted of Mikhail Savransky, who was appointed by the institution, and two German arbitrators, Jens Potten and Michael Schwarz, who was appointed by the respondents, and he dissented on jurisdiction and on the merits. So the basis of the arbitration proceedings was an arbitration agreement, which contained in the settlement agreement dated 5th of March 2007. And the parties to the settlement agreement were, Oksana, can you please move to the second slide, please? Yes. So the parties to the settlement agreement was the claimant, a German individual who resides in Moscow, and his affiliated companies, including LLC Guta, a Russian company that was involved in production and distribution of juices. And only one of the respondents was a party to the settlement agreement. That company is 2 RHV Verwaltungs GmbH, formerly known as Ekes Granini Rusland Holding. So we call it signatory respondents. So, but there were also 4 other respondents in the arbitration proceedings. 3 of them were companies of the Ekes Granini group, which were either parent or sister companies of the signatory respondent. And the 3 other respondents were German individuals. 2 of them were directors of the signatory respondent and signed the settlement agreement on its behalf. And the 3rd one was the director of the signatory respondent's Russian subsidiary, which was not a respondent in the arbitration, and who signed the settlement agreement on its behalf. Oksana, next slide, please. So the arbitration clause contained in the settlement agreement, and the settlement agreement resolved disputes relating to previous relations between the parties with respect to production and distribution of juice in Russia. So the settlement agreement was performed in full and no claims were made in relation to it. But the settlement agreement also provided that a new set of contracts was to govern further relations between the parties. And these contracts were entered into on the same date as the settlement agreement. We call it new contracts. So these new contracts were option agreement between the signatory respondent and an affiliate of the claimant with respect to shares in the Russian subsidiary. And there was a separate arbitration clause in that agreement, which provided for a German institution for arbitration in Germany. 3 other agreements were relating to production, distribution, and storage of juice, were entered between signatory respondents' Russian subsidiary and LLC Guta, and they provided for arbitration in the Moscow Chamber of Commerce and Industry. And the claim actually relates to the new contracts. The claimant alleges that the respondents, by their allegedly tortious actions, caused a breach of the new contracts, which caused damage to LLC Guta and led to its bankruptcy. In the award, the tribunal applied German law to the arbitration agreement and also to the question of whether the non-signatories are bound by the arbitration agreement. And this conclusion was based on a general clause in the agreement which provided that German law is applicable to the relations of the parties. So the tribunal concluded that this also meant that German law applied to the arbitration agreement. And then the majority of the tribunal, i.e. Mr. Savransky and Mr. Potten, accepted jurisdiction with respect to all 7 respondents and ruled that the respondents must pay a compensation almost in full. Mr. Schwarz dissented. So what are the conclusions of the court, the Moscow Arbitrage Court, which is the first instance court which hears applications for setting aside of such awards? The court didn't disagree with the tribunal that German law is applicable to the non-signatory issue. At the same time, the court didn't verify many of the statements made in the award in support of the conclusion that the non-signatories were bound. And in particular, if you look at the judgment, you can see that there are lots of quotes from the award in support of the conclusion that non-signatories are bound. And those quotes also relate to, refer to some documents which were only in German language, which means that the Russian court can only examine documents which are in Russian language. So the fact that the court referred to the award and to the documents which were only in German means that the court didn't examine itself these documents, but relied on the conclusions of the tribunal, which clearly, from the Russian point of view, the court cannot do, because in case there is a question about absence of a valid arbitration agreement, Russian court has a duty itself to examine whether there is a valid arbitration agreement. So the court cannot say that, well, the tribunal has established that there is a valid arbitration agreement, so I rely on this conclusion. It's also quite interesting that what seems to be the main reason why the court accepted jurisdiction was a clause which you normally find in settlement agreements. It's basically that the parties to the settlement agreement are responsible, like in this case, each party to this agreement is responsible for ensuring that its affiliates do not assert any claims in connection with the circumstances and business relations referred to in this agreement. So normally when parties enter into a settlement agreement, then they are interested in excluding any possible claims with respect to these relations, including by officers, affiliates, and other possibly relevant parties. So such a clause was also included in the settlement agreement, but the conclusion which the tribunal and the court made was that all these affiliates which are referred to in this clause are also bound by the arbitration clause.
Yeah, Timur, this is just so strange in a sense to me. This clause suggests exactly the opposite. I'm sure you're going to say, yeah, well, I agree with you because it was my position. But I mean, a lot of times what you're looking at is clauses, the tribunals will be looking at clauses that suggest that the contract can't be performed unless a non-signatory is doing the performing, right? But that's not this clause. I mean, whether or not that's right, that's another issue. But this clause suggests the opposite because it's a procurement obligation. The signatories carry a liability to make sure that a third party does something. It's not that the third party has to do something, right? Isn't that?
Absolutely. That's only underlines that the other parties are not parties to the agreement. Because,
right.
Otherwise, there would not be an obligation on the signatory. Thank you for this comment now.
Let me see. Do any of our do any of our participants have any comments that they react to? Perhaps particularly those of you who are familiar with Russian jurisprudence and the way in which the courts deal with these kinds of issues.
Maybe I would like to give a short comment. Being a German lawyer and from the perspective of German law, it is very surprising for me. And I heard that in the United States there is a doctrine of a manifest disregard of law. And being a German lawyer, I like this doctrine now. And just saying this decision of the tribunal is, from my perspective, the manifest disregard of a German law, because it is fairly impossible to draw this conclusion with this reasoning. You might come to this conclusion, but you need to use another reasoning. You must establish a close connection of the subsidiaries, or you must establish somehow a representation of the subsidiaries by the holding company, but not just using this clause in the settlement agreement.
Do you mean, Felix, do you mean that you would have to establish under German law a formal agency as a matter of law, that one party is the agent to the other, or it's something looser than that?
You have to establish, actually you have to establish an agency. And the German law is quite restrictive on it. There is some rare decisions which, for example, make a managing director of a company bound by the agreement signed by him for the company. But at least he was the person who were acting and who set his signature under the agreement. But there is no way to apply any other principles, let alone this provision in the agreement.
If we take a look at this issue, then as Noah pointed out earlier, these kinds of cases involving non-signatories are always very intensely fact-based. And so you have to come with evidence to show how you are able to meet your burden of proof that the particular theory applies. So when the tribunal is deciding on the fact-finding and then also applying the legal theory, which goes into the merits decision, although it's jurisdictional. So we have this conflict between fact-finding and application of the law, but in a jurisdictional context. So it seems, Timur, that the deference given to the arbitrators by the court in terms of their fact-finding, their law application, and the conclusions they reached was quite great. Do you think that's kind of the approach of the Swiss courts? Maybe we have a Swiss participants. We have some recent Swiss law where the Swiss court doesn't seem to want to engage in the fact-finding decisions of the tribunal. What do you think, Timur? Should there be? You mentioned that the Russian court has an obligation to determine that there is a valid applicable arbitration agreement.
Yes, Patricia, absolutely. If there is a question that there is no arbitration agreement or the arbitration agreement is not valid, then the Russian court has to examine this issue and has to make its own conclusions with respect to whether there is in existence an arbitration agreement, because and there are numerous clarifications by Supreme Russian court authorities stating that the court shall do this. But can we move maybe to the next slide, because there are also many other interesting suggestions by the courts. So another basis for jurisdiction with respect to non-signatories were that they were all involved in tortious actions, which allegedly took place after the settlement agreement was concluded, and that were closely connected with the settlement agreement. So the tribunal and the court concluded that because they were allegedly closely connected with the settlement agreement, all those who participated in these allegedly tortious actions were also bound by the arbitration clause in the settlement agreement.
Again, that's super weird because, I mean, in a lot of jurisdictions, you will have this focus on who participated in the performance of the contract and who participated in the termination of the contract. But whether non-signatories participated in tortious actions, that is in non-contractual breaches, but breaches of general civil law, how is that possibly relevant to the question as to whether the parties non-signatories consented to be bound?
Very strange to understand that. So next one is also quite funny. So the directors, so kind of three of the non-signatories were directors. So the court said, I agree that there is jurisdiction with respect to the directors because when they signed the settlement agreement, they knew the content of the settlement agreement. So they signed something, the content of which they were aware of, and therefore they are bound by the arbitration clause. So this, I can't understand the logic completely, because it was quite clear in the settlement agreement that they signed on behalf of the companies, not on their own behalf. So next one is that the directors who signed the settlement agreement were also directors of other respondent companies. So therefore, they signed not only on their own behalf, but also on behalf of other respondent companies' affiliates, which is also quite strange, because when they sign in a specific capacity. So the fact that a person is a director in 10 companies does not mean that if he signs on behalf of one of the companies, he signs on behalf of 10 other companies. Next ground was that the respondents participated in the proceedings and therefore they accepted jurisdiction, which is completely nonsense, because it's well accepted, generally accepted, that if you participate but you make objections to jurisdiction, then you do not accept jurisdiction. And on the next slide, you can see the two other quite interesting statements. So we made, so we requested actually the arbitration file, which was provided to the court, and we have not found German translations of most of the submissions of the parties that were made only in German, and evidence that was made in German. But the chairman of the tribunal, Mr. Savransky, doesn't speak German. So we had a question how the chairman could decide on this case, because it was made by the majority, when he couldn't understand what the parties were arguing, and he couldn't read the evidence. And finally, and maybe this is the one which explains everything, the court said that the claimant is in bankruptcy, and the bankruptcy was initiated by the managing partner of the law firm that represented this claimant in the arbitration. So the fact that the claimant is in bankruptcy means that the setting aside proceedings with respect to the award have a public character and is a factor against setting aside the award. And by the way, in the bankruptcy proceedings, the claimant said that this law firm is entitled to 40% of the proceeds from the award. So the fact that the court found that this has some kind of public character, and because of this, the award cannot be set aside, is quite troubling. It says, the slide says to be continued because we filed a cassation appeal. And I hope that we will come to a fair resolution of this case in the next couple of months.
Great. I think this might be a good opportunity to throw the next poll up and see what all of our participants think should be the applicable law. So again, you're going to have a poll coming up and see, do you think that that should be the law of the contract? Should it be the law of the arbitration agreement? Should it be the law of the seat? And when it comes to enforcement, should that be a separate law, or should it be both the law of the seat and enforcement? So we've got a few people who have now voted. Seems to be a close race between the law to the arbitration agreement merits. Whoops, arbitration agreement's taking the lead. That's a good Swedish approach. Huh? Law of the seat is slightly ahead of the law of the merits. Let's get a few more votes in. No one seems to think that the enforcement court should apply its own law. Great. Well, what do you think, Noah? I didn't put on the slide whether or not it should be the law of the ICC.
Yeah, I definitely wouldn't recommend the law of the ICC, whatever that might be. I mean, I do think there's some logic to the law applicable to the arbitration agreement. I've always thought that it's a bit odd if you're looking at it purely contractually and you're saying, like, the part, I want to know what the parties intended to choose, because there's other ways to get at it, right? Which I'll come on to in a minute. But if that's what you're trying to get at, that unless there's some evidence that the parties thought of some other law, it should be the law of the arbitration agreement, the law of the general law of the contract. the law applicable to the merits, right? Because after all, normally it'll say this agreement is governed by German law, for example. Well, if the arbitration clause is part of this agreement, and the parties could have said this agreement, except for the arbitration clause, is governed by German law. They didn't write that. So why wouldn't you conclude, based on the evidence available, that it is the law applicable to the merits? There's a different question, which is the non-signatory, as I said, will always be arguing, I didn't agree to anything in this agreement, so how can you bind me to that? And there, the law that has the closest relationship to the facts should be the one to determine if you believe that's the way to approach the question.
Well, you're swimming against the tide of the pool.
I love swimming against the tide. But the law applicable to the arbitration agreement, I'm simply saying, I mean, that seems to me obvious, but that's almost always going to be the law applicable to the merits.
Well, we're getting close to, unfortunately, to our end time. We have so many issues we haven't discussed. So let me just throw out to Timur and then to Noah to quickly pick up on one important point, and that is, do you think, Timur, and then Noah, that the analysis that we're engaging in on this non-signatory issue needs to be adjusted when it is a state or a state-owned entity, which is the non-signatory?
Well, thanks, Patricia. I think it's a very good question. Well, I basically, my view is that, the general rules shall be applicable, and there is no reason to make any exceptions just because the state is one of the parties.
Noah?
I think that's right. When state entities, whether it be a subdivision of the state or a state-owned company, concludes a contract, it's engaging in a commercial activity, and it's sort of stepping down into the role of a commercial party, and therefore there's no obvious reason why a state should be treated any differently. The interesting thing is when you look at particular state contracts, very often there are more complicated evidentiary issues about consent that arise, and that's why often it looks like they're being treated differently. The leading case that people have been discussing for years now is a case I was peripherally involved in, which is the Turkmenistan Bridas cases. The two arbitration awards in parallel, Kemir and Yashlar, having to do with gas concession agreements in Turkmenistan. And there, the two tribunals, looking at different contracts, but parallel contracts with very similar situations and very similar provisions, came to opposite conclusions about whether the state was bound. And interestingly enough, one of the differences was the Yashlar tribunal was seated in Sweden, and the Kemir tribunal was seated in Houston, Texas. And it was the Yashlar, the Swedish tribunal, found that there was no jurisdiction over the state. The signatory was a state-owned company, Turkmenneft, and the Houston-seated tribunal found that there was jurisdiction over the state for the reason that there were obligations in the contract that said the tribunal only the state could fulfill, particularly the issuance of certain permits. That award was then annulled and went up and down in the U.S. courts until it was found that Turkmenneft was actually an alter ego for Turkmenistan, and the decision was upheld. But there, it was precisely this question as to whether in a state contract, even if it's a state company or a subdivision of the state, whether only the state as a whole can perform certain obligations under the contract.
Yeah, and I guess this all goes back to, at the time of contracting, it's much better to try to anticipate these issues than to argue about them through the courts, which can be a long process. We've reached the end of our time, but I would like to, if anyone needs to leave, they can leave. I would like to launch our very last poll and invite anyone who would like to make a couple of comments before we actually depart. So let's take the first poll, and that is, do you think that these issues need to be harmonized? And if you don't think they need to, that's your last choice. If you do think there should be some unification, then should it be through international conventions or instruments, through national legislation, through soft law, Or should this be part of standard contract terms, that we just need to do better contracting and quit trying to patch up the bad contracting with these different doctrines? So we're getting, it seems that not many think there shouldn't be some harmonization. Soft law does not seem to be so popular. So what do you think, Timur? Are these results what you would anticipate, or do they surprise you?
Well, it's quite surprising, basically, because I think this is a purely contractual kind of question. So you apply international private law, and you determine which what is the governing law, and then basically on the basis of this governing law you decide whether there is a contract or not. So from my point of view, the most appropriate way would be to defer, as it is done now, this question to the applicable national law.
I think it would be helpful if national governments, if countries would adopt legislation or modify conflict of laws, there's private international law, to specifically address the question of the law applicable to a non-signatory to an arbitration clause. I think that would be helpful. Otherwise, because the whole point is not to bind more or less signatories, but to have more clarity as to whether a non-signatory will or will not be bound, for predictability's sake. And that can be done two ways. One is you make sure that in every contract you say nobody is a party to this contract but the parties, but the signatories, and anybody who thinks otherwise is wrong. And you make sure you're absolutely clear. The other way, and it's a complementary way, is to make sure that everybody knows when they're contracting what system of law they're buying into with respect to that key issue. And for now, that is definitely not obvious.
So I guess what we need to do is to always keep our eye on the choice of law issue and also what facts we have. I think we could sit around and discuss this all afternoon, but unfortunately we were supposed to have ended 4 or 5 minutes ago. So unless someone in our participants would like to make an intervention or a comment or a question, I think Noah and Timur and I at least can be here to discuss with you.
Sorry, Patricia.
Was there any?
Missed what you said.
If anyone would like to make a comment before we exit the meeting, any of our participants want to make a final comment or a question? No. Well, with that, thank to all of you for coming to the session today. I wish we would have more time and that we could have heard more of your opinions on these issues and your experience. Timur, thank you very much for taking your time to share the Russian case and your thoughts with us. And Noah, thank you also for taking your time to share your insights.
And thank you, Patricia, for a wonderful moderation job as usual.
Mm-hmm.
Thank you, Patricia.
Thanks, and thank you to Glenn and to everyone at the ABA and to the RAA for arranging this. So with that, should we leave?
Yep. Goodbye, everyone. Thank you.
Okay. Bye-bye.
Bye. Bye.